had way too many hundreds of clients, and therefore at some point felt like it would be nice to be able to actually look something up on occasion. I was in court all the time. So I moved from there to the Juvenile Law Center, where I did a lot more impact work. I did class action work, I did regulatory reform, kind of a whole range of strategies where you employ law to try to change how the experience of children, particularly children in state systems, abuse and neglect, as well as the delinquency system. And in that context, I just started tripping over issues that I thought were really interesting. And is anybody writing about this? And shouldn't we be thinking about developing this area of law? And that is really what led me back to the ivory tower, trying not to stay too much just in the tower, but back teaching and thinking and writing about some of these issues and other issues as well, relevant to children and families' experience with law. So when I started doing the work as a practitioner and some years later as a scholar, I came to a field that was a pretty new field. So children as constitutional rights holders had been sort of recognized as such since the 60s, first in the context of the delinquency proceedings, where it was very much perceived as a kind of criminal procedure, and that was a sort of an important move in children's rights. But the most important thing that came out of that was a declaration, the Children have Constitutional Rights too, which pretty quickly spread to other areas. So soon after Roe versus Wade was decided, we had cases where the court was grappling with the extent to which children as well, adolescents, could make decisions about whether or not to have an abortion without parental consent, without parental notice, and the like. We had cases in the school context where children were wearing black armbands and printing articles in the newspaper, and the question is the extent to which the state could limit what children said in those contexts, right? And in many other contexts we had, right, after the original Galt decision in the juvenile justice context, an application of constitutional analysis, constitutional rights to children. And the analysis really never spends time pondering why we give children rights at all, which is actually an interesting thing to think about. Philosophers love to think about that question. But seems to just sort of, now that we have Galt, assumes that even in Galt didn't spend a lot of time saying why. Basically, the suggestion is, you know, children are people too, so the Constitution applies to them. But a lot of time, or a fair amount of analysis spent sort of justifying giving children different rights than we give to adults. And that analysis, right, is always grounded in notions about how children are different because of their ongoing development, right? Children haven't grown up into those full adult rights, adults who have the sort of full panoply of rights. How are they different? How does this justify, in some sense, generally compromising their rights? And sort of another times I have written about why we should always think it's compromise and diminishing. Maybe it should just be different, and different might be larger, smaller, just different. That's not my focus so much here. What I want to focus on today is thinking about sort of the extent to which we, as lawyers, at the law, benefits from a better, deeper, more scientific understanding of child development and the hazards associated with relying on that kind of information. So in the early years of the cases I've described so far, the early years of the scholarship around the cases, the invocation of children's differences, that their ongoing development was kind of the common sense variety, the kind of conversation we might have if we just started talking about children's rights. Why are they doing it? Right? So courts would focus on children's difference, particularly their difference in capacity, their not fully developed ability to make good decisions, and tied with that, their special vulnerabilities, right? There are a lot of really bad things can happen to children. So putting those two together, we better make sure someone else is helping out and protecting them from their own bad decisions, making decisions for them, and the like. Some version of those two concerns, and a particular emphasis on this notion that children don't have the full capacities that we have, that adults have, and who therefore have more complete rights. So basic sense, right? And it was tied to what we sort of would expect to see the differences tied to if we're going to give them different rights. But increasingly, the scholarship criticized the court's analysis as sloppy, too unscientific. It's just like, where did that come from, right? Just they're sort of generally talking about difference in capacity. Has anybody tested this? Is it even true, right? There was a concern that there was a kind of inaccuracy and therefore a kind of unfairness to children. There was also a concern that there was inconsistency. If we just sort of say these loose things about what children can and cannot do based on these general common sense notions, are we really coming up with fleshing out a system of sort of a full understanding of rights for children across various contexts and issues, which was sort of going on in that 2 or 3 decade period, that is coherent, right, that really works across those domains. At the same time, we had social scientists start getting more and more interested in this legal decision making and starting to design research that more specifically tried to test what was being assumed in the law. So a lot of focus on decision making capacity of children and adolescents. And before I go any further, I wanted to little asterisks to talk about adolescents versus children. There's a lot of interesting sort of implications for thinking about very young children as well. You'll notice that the focus, examples I give, the focus of my discussion is going to be much more on adolescents. There's a reason for that. I mean, it's partly that some of these issues have a real sort of biological developmental component, right? You don't have abortion issues and birth control issues and the like for the really young kids. And some of it is whatever you want to say. You want to say cultural, some of it may be cognitive, sort of, right? There's a complex developmental picture, but the issues that come up, whether it's, you know, how offensive, you know, what can I say in school? How offensive can I be in my speech in school? If the question is, do I get access to birth control? You know, and you could sort of go on, if the question is, how do you treat someone who's committed a criminal offense, right? If you sort of go through the litany, they are issues that for the most part are pressed by adolescents, sort of how we think about adolescents. But I would sort of welcome questions, and there's some really interesting questions about how the law treats the youngest children. So when I talk about children, and I'm focusing on adolescents. And this research that grew up, inspired by the law, by the developments in the law, was very focused on sort of adolescence and the cusp of adolescence. We're starting a lot of research starting with 10-year-olds and going beyond. And the first wave of the research that was applied to the law was very focused just on cognition. And there was a lot of, aha, look, even by 14, children are pretty much at the same place as adults in terms of their cognitive capacities, or this basic idea of ability to engage in abstract reasoning, to understand at sort of a range of hypotheticals, and to sort of to engage in a process of weighing those various possibilities. Middle adolescence looks pretty much like adulthood. So kind of the first wave of scholarship trying to take account, a legal scholarship trying to take account of this literature suggested, man, we should maybe be giving very generous autonomy rights to teenagers. Second wave, which was very much inspired by a concern that what kind of implications does this have in the juvenile justice context? We want to say that 14-year-olds are just like 18, 19, 20-year-olds, and therefore should be held equally responsible, should be treated as adults, right? There was a lot going on politically that was pressing in that direction. And second wave of social science research aimed at what was going on and what was happening in terms of legal decision making, focused more on psychosocial development and concluded that children lack certain kinds of capacity, not so much sort of pure cognitive capacity, but more their ability to engage in mature decision making, right, to sort of control their impulses, the taste for risk, the taste for, you know, the sensation-seeking inclinations of adolescents look different in the studies, not surprisingly, right, from that of adults, and that had important implications for decision making, as did adolescents' response to pressure from peers, different from what we see as people get older, with important implications for their ability to control their situation, the capacity to exercise certain kinds of choice in a potentially criminally tempting setting. So as this development, so we have the legal scholarship looking to the social science and saying, look what we're learning, what does this tell us about what the law, how we should shape the law and legal rights for children. And of course, the social scientists very much engaging increasingly collaboratively with the lawyers and sort of trying to hash this all out. Became even more complex and scientific with the introduction of the brain science, right? Sort of in the very end of the 20th century, an increasing ability to use MRIs to study a brain while it was functioning and to look at the differences in actual brain, sort of how it was wired and how it was functioning, and comparing adolescents and adults. Again, supporting the idea that there's something very different about adolescents, and this was invoked to argue that they should be treated differently, particularly in the context of the delinquency and context of the criminal system. So, this general call was for the courts to embrace this greater understanding of the social science, right? What the court has done so far, maybe they've got it roughly right. It's pretty thin, pretty sloppy. Sometimes they even say things that are wrong. Not sure it can really map out across the whole world of legal rights they're describing. So a real call to get more accurate, to get more precise, get it right. If you're going to craft different rights for children around their developmental differences, let's look to the social science and design that right to really reflect what we have learned from the social science and now the brain science as well. And that call was very much answered. That approach was embraced in the Roper decision, decided in 2005. So in Roper, some of you I'm sure are familiar, but the Roper decision concluded that it was unconstitutional, cruel and unusual punishment, to impose the death penalty on people who had committed their offenses before they were 18, right? And it was significant in a number of respects. One thing, it was a pretty quick change around from a conclusion reached less than 20 years before, that the line was 16, right? That over 16, basically looking at trends across the country, was not constitutionally problematic. The death penalty could be imposed for offenses committed by people over 16 and not under. And now, less than 20 years later, the line was redrawn at 18. But most significant for purposes of our discussion today is that Justice Kennedy really embraced the idea that the social science can tell us what to do, essentially. That's my criticism. I'm getting there. But basically, he looked at the social science, very well presented to him, and some very good amicus briefs that were basically presented by the people who had been leading this interdisciplinary scholarship, and said, and concluded that, talking about the death penalty analysis, we ask about proportionality. Death penalty is supposed to be reserved for the worst of the worst. Because of children's developmental differences, they are not the worst of the worst. They are less culpable, essentially, he concluded. Now, there are other lines of analysis in the Roper decision, including the international comparison, which has provoked a lot of discussion, really interesting, but I'm just completely setting them aside. I actually think it's fair to say that the most important in terms of what feels like it's driving the decision making is the social science piece. But, I come with a little certain bias. It has certainly been the response of scholars and advocates and lower courts going forward to sort of look at that as a very significant, important piece of the analysis. So kind of but-for sense, and a real sort of step in the direction of the court's embracing of this better understanding of children's development to formulate law. So the court, it identifies three things that are different about children that justifies a conclusion that they're less culpable. One is and the three categories actually are, you may feel like they slip a little bit together. I actually think they do slip a little bit together. So that's a good thing to notice, not something you should be concerned about. Or if you're concerned, it's not a problem with my presentation. As I go back in the decision, you'll see they sort of slip around. But one is a lack of maturity of judgment, and this has this idea of including this notion of failure, difficulty in controlling impulses and the like. The appetite for risk. And second is this greater vulnerability to external pressure, most particularly peer pressure, and to some extent context pressure, and greater difficulty extricating oneself from whatever that context might be, right? When you're not yet an adult, you don't have as much control over where and how you're living. And three, that the fact that adolescents' identities are still in the process of formation, and therefore bad acts cannot be associated with, assumed to be to reflect bad character the way they can be for adults. So these three reasons do very much map onto the kinds of analysis that's offered by the amici. Again, the amici are the psychologists and the lawyers have really been focusing on trying to get it right, figure out the social science. And as a result, the decision was widely heralded as a real step forward for an analysis of children's rights, and assumed to be applicable and relevant not only to other cases relating to the juvenile justice system and the criminal justice system, but more broadly in thinking about legal rights and responsibilities, including constitutional rights for children. My own reaction, tell from where I'm sort of how I presented things, is more mixed, and that sort of inspires where I'm headed with this. So on the one hand, to the extent we're going to rest our analysis of children's rights on an understanding of what is different about them, and particularly developmentally different about children, seems like a good thing to move in the direction of a more sophisticated understanding and employing that more sophisticated understanding of how they really are different, right? So in that sense, a step forward. The concern is, what's problematic is the suggestion that there is a fact of the matter based on social science that basically is giving an account of current capacities, right? And turning that into the legal answer, suggesting it's almost dictates the legal answer, right? So the language itself is problematic. So children are less culpable. Well, culpability is ultimately a legal assessment, a moral assessment, reflected in our law, not a, sort of a social scientific assessment. But what I'm more interested in is thinking about the opportunity lost with this kind of a framing, which is the opportunity for the law to recognize that as part of culture, as a part of the way, sort of reflects our treatment of one another, including our children, it is an opportunity to affect how children develop, right? So it's just really missing the sort of message of fact of the matter, misses the potential, that the real dynamic relationship, potential dynamic relationship between development and law. So I want to sort of very quickly run through some things that I think are problematic about the Roper sort of fact of the matter approach, and then sort of talk about what I think are implications, or maybe sort of a better way of thinking about this. Okay, some problems. One is this idea that anytime you're suggesting this, fact of the matter, this is how what children can and cannot do, right, to a large extent. There are problems if it's not quite right? So there are limits in how accurate things can be. Now, of course, this is always true with any kind of age lines, right? Anytime you draw an age line, it doesn't exactly reflect where everybody exactly is. But the difference seems to me in saying sort of law is drawing a line based on this sort of rough understanding, and social science can help inform the law, but sort of the law is making a decision about where it makes sense to draw the line, influenced by the social science, right, which is what we do. We draw the line at 16 for driving. We're certainly not saying people under 16 can't, don't have the capacities to drive, and those over 16 do have the capacities. We're not saying that. We're saying the law has made a choice, and sure, the social science and some other kinds of data have shaped our decision, but it's a legal decision, right? So there's a shift in Roper, there's a sort of suggestion that it's almost that it's sort of taken out of the hands of the law, some of the language. The other problem with the particulars is that even as an aggregate line, it's probably not in the right place. Most of the social science that supports the idea that we shouldn't draw the line lower than 18 actually suggests that we should draw it higher, and maybe significantly higher, right? 20, 21, 25 in terms of when some of these, the maturity of judgment and the sort of the shifting in terms of how we make decisions in the kinds of ways that the court is talking about. Sort of the 18-year-olds don't have it yet, neither do the 19-year-olds for the most part, right? So nobody's going to argue, or nobody's going to successfully argue, that's for sure, that we should set it at 25 because this is what the social science tells us. Why not? Well, because the law is in charge here, right? It should be. But then the suggestion that it's not, which I think is in Roper, is just sort of, it destabilizing, if nothing else. It subjects it to the mockery of Scalia's and the like, and legitimately so on that ground. There are other problems if you look at the data, right? And again, the brain science data sort of backs all this up. Is wow, girls and boys are different. I mean, I'm a big believer that we sometimes exaggerate the hardwired part of it, but there is, for whatever reason, you look at those brains, and girls are ahead of boys. Sorry, guys. If you look at behavior, girls are ahead of boys. Does that mean that we actually would have, if we're really basing it on social science, like different notions of culpability, for girls and boys? No, we don't, because we have notions of sort of bottom line, we're drawing some legal lines, and that's as it should be. But again, the concern is the Roper language isn't really consistent with this idea that ultimately what we're doing is drawing legal lines with some sort of influence by legal doctrine, moral commitments, and the like. Another problem is, what are the implications for how we think about adult rights, right? So we have this increasingly sophisticated understanding of children, which we're suggesting sort of tells us how to think about their rights. But we don't shine the light on adults at all. And if we did, right, very rarely perform at the level they're supposed to, and many don't even have the capacity in the sense that we can sort of sustain in the kind of context that matter and the like, right? So we don't really want to get into the business of saying, right, well, maybe, I don't think we do, adults shouldn't have these rights either. Look what we're saying about kids, right? Let's abandon these rights altogether. I don't think we want to say that, although it's sort of interesting to think about why. But it's an odd kind of legal analysis that insists on this kind of precision and detail and sophistication on one side of the line, where it's so irrelevant on the other side of the line, which is what the children are being compared to in justifying their different treatment, right? So that seems to me is analytically problematic. There's another problem, which is this idea of mismatch across different areas of law, which has not gone away, right? So remember I said this was one of the concerns that called for this use of social science. Let's make it a consistent across law. Well, have we really done that, right? We need to worry that the kinds of arguments that we're offering with greater sophistication in one context, very particularly focused on asking about culpability, what kind of implications that has for how we think about autonomy rights. Now, the simple-minded, way of putting this problem is, how can anyone, on the one hand, say people are mature enough to decide whether they're going to have an abortion or not, but they're not mature enough to figure out that it's wrong to kill people? Okay, so the analysis has gone beyond that simple idea. It's easy to put that one to rest. But at a more subtle level, I think it actually is kind of tricky, right? If we insist that there are all kinds of things, that all of the things that we've discovered in our greater sort of our digging deeper in terms of the psychosocial aspects of development, sort of what we think goes into judgment, how we think about risk, how we think about long-term, short-term, and all of that sort of bearing on who we're going to hold responsible for what? It's hard to say. It doesn't have some bearing on how we think about autonomy and what it's right to even attribute to individuals, let alone whether we think it's kind of the level of decision making that justifies the full right. So I think there's still there are real problems created if we're saying that sort of this is answered by our understanding of the developmental status quo. Finally, a problem that I think I have the hardest time thinking about, but I'm convinced there's something here, is thinking about the expressive value of this language, of the way the decision is justified. And expressive value in law is always this tricky subject. It's really interesting. There's something there, the idea that the law is doing something just in its expression, even aside from it. On the other hand, right, it feels kind of like, it's kind of soft stuff. What are you really saying? But I think that it's worth thinking about in terms of both the potential child audience and maybe more plausibly in the context of Roper, the political, we the people speakers, that the message we give in terms of how we justify this difference of treatment for juveniles matters, right? So the message of Roper is essentially, we blame you less for these heinous crimes, right? And I don't think individual juveniles sit around and study Roper and think about what that means. But there is a way that there's a kind of trickle-down effect in terms of these legal messages and how it actually, I think in some ways, can cash out at least a little in terms of the shape of the culture and our understandings. But it doesn't take any trickling down to have it cash out in political terms, right? People who are up in arms about crime and want to respond are just not, even if there are other ways to convincing them it wouldn't make sense to have a juvenile death penalty are going to be appalled by the idea that we're sending a message that in some sense it's, we're blaming you less for these terrible deeds. So the notion that there's some kind of expressive thing to be concerned about here is kind of how I would say identify that item on the sort of my list of problems. But I can't say I'm completely satisfied with sort of how I want to think through that and how much that's really a piece of what we should be concerned about. But so here's how I think is a better way to think about this, right? So my objection is, fact of the matter, here's what we know based on social science that at its best can capture the sort of the here and now of an aggregate understanding of development. What's a better way? So my view is a better way does more looking forward at how development is affected by individuals' experience with the law, and particularly children's experience with the law. And there are two kinds of effects that I care about. One is still in the world of capacity, right? So it's thinking about how one's experience with the law, what the law says, maybe that's expressive piece, or how people are treated, and how that's experienced, how that actually shapes how people grow up. Whether it's a direct experience for an individual or whether it is sort of in terms of shaping a culture. The other is this issue of identity formation, which I think is given, it's actually given a nod in Roper to Justice Kennedy's credit, but I think it's really not taken very seriously. The decision rests on these notions of capacity and impaired capacity. The idea of identity formation, sort of a wholly different line of developmental psychology, it actually grew out of the psychoanalysts, interestingly enough, but it sort of seems kind of irrelevant at this point in terms of how it's understood by people really studying identity formation. Note one, that is the central project of adolescence and young adulthood, sort of sorting out, who am I? What makes me a consistent individual over time that I recognize and others recognize, that sort of holds me together as a psychological matter? What do I believe in? What do I care about? What are my values? But also, very importantly, I think for this context, how do I relate to everybody else? Other individuals, my society, my government. Who am I in relation to those entities and individuals? That is a huge piece of what's going on in adolescence, right? And the idea is that there's just no way that the law and individuals' experience with the law doesn't have at least some effect on how that all cashes out, in my view. Now, I want to leave lots of time for comments and your thoughts, but I want to say a little bit about sort of exploring about what this would look. So let's get concrete. Sort of how would this play out? So in Roper itself, I have to say that I squirmed a lot about. Okay, what am I exactly saying about what would Roper come out the other way? Would Roper come out the same way, but with different analysis? And I think, maybe because I think it's really a bad idea to kill people, especially people who have committed offenses before they're 18. Why? They're still developing. I think that's relevant. Not so much because I think it's right to say we should be blaming them less, but because it is an appropriate decision for the law to make that we're going to give them a chance to grow beyond it. That has a developmental component, right? We have some notion that children can grow beyond it, but it's not just a developmental component. I mean, if you look at the arguments in the life without parole cases, it kind of drives you crazy, I think. It drives me crazy to read the arguments that are so. The lawyers kept being caught up, essentially saying that after 18 you're not capable of change, and of course that's nonsense. It's people get maybe less and less capable of change as they get older. But part of the idea is we as a society are only willing to tolerate the potential for change up to a certain point. We have a different idea about childhood, which has all kinds of implications. But one seems to me quite sensibly would be, as we sort of demarcated a period where we make very different trade-offs in terms of what you get, what you don't get, what kind of protections. And the idea is, in that space of time, we're giving you some kind of opportunities to shape yourself up into someone who can be a part of our society, that at some point we make a decision, so we're cutting off. Now, how does that fit into constitutional analysis? On the one hand, it's extremely tricky to fit it in. On the other hand, I generally think it's a mistake, and this is something I've written about in other contexts, to insist that children are really different, but we're going to sort of jam them into the analysis we've already constructed that may or may not make sense for adults, right? So I'm more willing to say, if I were master of the universe or just good enough, a justice on the Supreme Court, to say, we're starting with the basic questions are questions about our evolving standards of decency and I think, what do we learn about ourselves from our patterns in law? And there's plenty to point to there to say, we do make a commitment to giving a kind of opportunity to individuals up to a certain age. And that the problem in the end with Justice Kennedy's analysis, he was just didn't have the guts to go that far in a way. I mean, he really wanted to go there. That's really what's going on, I think. But that he couldn't say that, so he had to be able to sort of tie it into these, these facts of the matter about capacity that could sort of plug in and work, kind of, although it's still a push, under the current doctrine. But I like to think about sort of what are the implications in all kinds of areas beyond just thinking about issues of culpability. Of course, there are a whole category of cases that are autonomy rights cases and raise all kinds of interesting questions. And I just want to mention sort of a couple things in the context of children's First Amendment rights, and then I want to say something about process rights more generally. So there's a line of First Amendment cases, and I mentioned I think I mentioned the Tinker case, the black armband case. Maybe I didn't mention it specifically, but it was the earliest case where the court recognized children's constitutional rights in the school context and protected children's right to protest the Vietnam War by wearing black armbands. They had been suspended, which led to the legal challenge. The cases that followed that got to the Supreme Court, and there are lots and lots of cases that, right, as in all areas, but there's a huge number of First Amendment school cases at the lower court level, very few decided by the Supreme Court. But two I want to just mention very quickly to sort of think through, cash out this idea that we should be thinking about, rights in terms of the law. The law should be concerned with how the shaping of rights affects how children develop. One was a case of articles in a school newspaper. They're discussing issues that the principal thought were inappropriate. Another was I know some of you have had these cases, Hazelwood and the Bethel case, where it was a student was speaking on behalf of someone running for a political office in the school, and it was a vulgar speech that involved some gestures and innuendo, and a lot of the people watching the speech really got into it, so there were lots of laughter and gestures, right, that were highly sexualized. So in the Hazelwood case, the principal said, not time to do this in a more refined way, and just pulled out 2 pages of the paper, lots of articles beyond the 2 that he found objectionable. In the Bethel case, the guy got suspended and was taken off a list of people who could speak at graduation. So I'm using these by way of example more than anything else to say that there are 2 things. One is a more sort of thinking about developmental effects approach might lead you to conclude that the cases should come out the other way, right? I think in general, my analysis pushes in the direction, particularly at autonomy rights, of being more generous with it, sort of affording autonomy rights, but it need not. I don't think the analysis dictates end. So you might say that the cases should have come out the other way. You might just say that the court should have been more careful in its particulars in analysis of what was and was not constitutional. So what do I mean by that? So in the Hazelwood context, the idea that it was not only, if it's okay to take out the articles, it's okay to do it in a way that eliminates all kinds of other speech that wasn't offensive. Wait a second. So shouldn't it at least require some kind of care and extra efforts and maybe even extra expenses on the part of the state to get at the legitimate offensive speech if it was legitimately offensive? The other thing is it was defended completely in terms of the pedagogical value, teaching the students good journalism practices, with a suggestion that in the end, part of what we're doing is preparing them to be good speakers as adults, so they have to learn these lessons, while at the same time it was not done in a way that taught them any lessons at all. There was no effort to turn it, to actually reflect those kind of commitments. So again, you could say, all right, some editing might be appropriate if you buy that part of the analysis, which is interesting and complicated, and we go into another time. But you could also say, okay, even if that's legitimate, there are some things that cross the constitutional line. If we're thinking about how this is experienced by the children, understood, and how it actually turns into something, it shapes their understanding of what kind of citizens they're growing up to be. In the Bethel case, the real problem seems to me, I mean, I think it's a really tricky case, but the real problem in the end is whatever else you do, you can't keep them from speaking again, right? That's got to be wrong. The message is what you're teaching them is how much we celebrate free speech and certainly not prior restraint because that's so chilling, and the message is, right, that you have somehow become a speaker that we don't get to hear from anymore. No, whatever else you do, that can't be along the list. And as a matter of fact, the students all voted for him after they heard he wasn't allowed, which is classic student response. And also intriguing when you think about sort of how these understandings of self and rights develop. Last thing I want to say is there may be more, the greatest value in terms of thinking about developmental effects that we can accomplish through law and the affording of legal rights. It probably comes in the context where we're focusing on process. And because in that context, we're really thinking about how the law is, really coming right up against student and child experience, right? We're thinking about process. We're really thinking about treatment in some kind of a direct way, and it's a direct way that young people will experience. And we might be particularly interested in process, particularly concerned about process, where the young people involved are most vulnerable to developing an understanding of themselves and a perception of how they relate to their society, to their government that is the most alienated and disenfranchised, right? We might see the opportunities, so this would be particularly in the juvenile justice context, of actually having an experience, these young people having an experience with law that conveyed messages about how our law perceives individuals and what kind of rights we afford them and how our government relates to individuals. That is really not, there are not going to be other opportunities for some subgroup of individuals, particularly in these kind of contexts. So we might say that, sort of like it's all good and well to say the law is going to have some effect as well, and we should take that into account. Maybe in a lot of contexts it's unrealistic to think it's going to have, make a huge difference in any particular legal context. I'm convinced that at least in the context where we're talking about process rights, and at least in the context where children are growing up, developing a sense of identity that is predictably very distinct, sort of very cut off from, right, sort of defining themselves as not part of society, not part of a community, how the law is designed could have a profound impact. So other areas, at least it's interesting to think about theoretically, not yet sure how much I want to say it's going to, in the end, make enormous difference. So, questions, comments? Yeah?
It seems like in the due process of the identity formation, seems like maybe say you want to give children more rights, but it might work in the opposite way for First Amendment rights. And I'm just thinking, like, if we want the law to be more even-handed to adults, wouldn't it be better to restrict children's choices of how they portray themselves so that sort of all come out a little bit more the same?
The same. So, we want to be the same?
Well, yeah. Then the law can treat us all more fairly if we all sort of have the same training to become citizens or something like that. Maybe.
Well, it's a question of what you want to go into that training, right? So one of the examples I love to give about the adults that we end up with, right, is we have this wonderful idea of the marketplace of ideas. And it's really, a big justification lurking in the back, of a lot of analysis of why we give protection to speech is because, get those ideas out there, people will pick and choose, they'll really be able to make the best choices, and this matters for our ability to govern ourselves as democracy, right? If you look how people behave, again, sort of thinking about current adult behavior, people do not shop at the market. I mean, they go back to we love to sell, but we don't really like to buy, or if we buy from people we already, right, with the merchants we're already familiar with. So we grow up to be adults that don't really know how to engage the marketplace very well. I'm not sure the best, it seems very plausible that the best thing we could do in raising children to be successful adult rights exercisers is to give them a lot of speech autonomy in a context where they're, people are paying attention and can help them learn lessons from it and sort of help them process it, right? We might be able to be the same along a dimension that we really want, which is, wow, we kind of learn from each other, listen to each other. We actually speak in order to try to influence decision-making, which is, a fundamental commitment to our democracy. So this sort of issue of the same. I mean, my first resistance was just like, well, we're not very committed to same. Like we're committed to pluralism in a lot of ways. But I share with you the impulse that there are some bottom lines that we would like to produce in our adult citizens for them to function in the way that our cases claim they do, and they usually don't. Wow, we could maybe there's some opportunity to address some of that, to do better by thinking about how we structure children's rights. But for me, that suggests in the speech context that you would push in the direction of greater autonomy. Maybe not across the board, right? The Bethel case, the reason I think it's so tricky is, on the one hand, it's, wow, straightforward free speech in a kind of political context. On the other hand, it's highly sexualized speech where the mostly girls in the audience are feeling completely like they want to run from the room. It's like, well, schools should be able to, there are a couple things going on here at least, all sort of, at least, both focused on this idea of sort of how are we raising people to become effective, functioning adult citizens. Long-winded answer. I don't know if it got to what you're looking at all. Yes.
Didn't the court in Morse essentially do that? It used the social science, Morse v. Frederick,
yeah,
to say,
I'll give the background unless you want to, but yeah, go ahead.
I mean, to say that, drugs are so bad, and particularly are bad in the youth context, and therefore, we need to restrict that speech. And I guess, really my question is, when has the court ever effectively used science in a constitutional analysis, taking into account all of the factors? It doesn't seem to me that there's any context in which they've successfully integrated social science into that. And is there a model that serves as a good?
Yeah, it's a great question. I think there are at least 3 questions, and I'll break them out, and then I'll think of whether I think if there's a really good example of when they've used science well. I'll tell you how I think they should use it that would be better. So the very generic question is like, beware courts using social science, and there are lots of examples, some of them kind of scary, sort of chilling, sort of early use in sort of race cases and the like, but it's sort of across the board where we say, okay, the whole point of science is it keeps, you learn more, you keep changing, and law sort of tries to be fixed and principled and not moving too fast, and those can produce all kinds of disastrous consequences. Made worse by, as Scalia would say, the sort of, justices looking around and picking their friends, which is the idea is there's something out there that can say support just about anything in the literature, and how do you avoid that danger? So huge dangers of that sort, I'm just going to agree with you right away. It's for me a reason that we should be worried about the law not abdicating too much to social science. You should never say, social science, therefore law, right? So I'm going to take it as a friendly comment in that regard. So I want to make sure I remember all 3 layers. So I'm going to get to Morse as my 3rd layer. So the second is what I think you're getting at, and Morse was a context in which you brought it up, but it comes up all the time, is they do use social science, mostly indirectly, but sometimes directly, to justify withholding rights by identifying some kind of a problem or some kind of a need. I don't think that's illegitimate, especially to the extent that they're deferring to democratic decision-making about real problems, right? What I'm arguing is that it should come in on the other side of the equation as well. It shouldn't just be, there's some kind of a state interest that justifies taking away these rights. The court should recognize that how they're articulating rights and how they think about rights and how they justify either giving children what adults get or not should, among other things, should take into account the developmental impact of their decision, as well as whatever's on the other side. So it's going on anyway, and this is a way of saying it should be more completely a part of the analysis by being on both sides. That's sort of the part. So now Morse, I love Morse, because Morse is a case where, it's a pretty recent case, where this was the Olympic torch was going through a town in Alaska. A guy who, interestingly enough, among other things, by the way, was already 18, so he was still a student, but he wasn't a kid. He loiters in, I just added the word, and so the school is all allowed to be dismissed to come out to the street to see the Olympic torch pass, and there are, of course, cameras, TV cameras all over the place. He and a bunch of his pals have this idea, they want to be on TV. They walk up, I don't think they've even been at school. They walk up, they unfurl a banner that says, "Bong hits for Jesus." Okay, so one of the fun things about the opinion is seeing the justices puzzle over what that really even means, right? Because they get the bong hits, but it's like, for Jesus, what? Is this a religious man? It's just, they decide it's mostly just, attention-grabbing garbage, and how much should that figure in, right? So there's that. But anyway, so of course the principal, it's across the street from the school, so these issues about whether it's even at the school. The principal sees this happen, tells them to knock it off or roll up their banner or whatever. This guy refuses, he gets suspended. And the question is whether that's a First Amendment problem. So I think taking my analysis, they completely screwed it up. And the reason they completely screwed it up is the justification is all like, okay, schools should legitimately care about drug use. Fine, right? There's a huge gap between the fact that schools can legitimately care about drug use and the fact, that there's not a First Amendment, it's therefore justified, not a First Amendment problem to tell this guy to roll up this banner, right? So the idea is if you think about how, not so much as an individual student, but the students in general, because this is the claim is, how could I not do something? I'm the principal, Bong Hits for Jesus is displayed. If I don't do something, it sort of looks like I'm soft on drugs. Okay, so that's absurd. The court should recognize, of course, nobody's going to say, hey, our principal's into some Bong Hits here. It's like, they're just going to say, if anything, they're either going to say nothing or they're going to say, wow, we really do have a First Amendment, right? I mean, so it seems like there's not going to be a confusion about the school's policy on drugs that's going to be tied to the reaction, whether this guy gets suspended or not. But there could plausibly be some kind of a message gained, a reaction to, despite the fact that principal, did you see her? She was going crazy, and she used, she talked for 15 minutes on the intercom after that. Didn't. Or did, and then wasn't allowed to, because we take this other thing seriously, like sort of either way you think about it, right, the court and thinking about deciding the particular case or thinking going forward what the rules should be, seems to be, come on, it's pretty plausible that there's some message to be gained in terms of, is there something to credit here? We really mean it. The way you can only really believe your country means it about free speech until they're tested against the most offensive, right, examples, versus, come on, this was really, were we worried that this was going to somehow prevent her from being effective in, controlling drug use in your school? So that's what I would do with the particulars of Morse. Yeah.
One of the most major age-related changes that I can think of was the one to change the voting age, and sort of one of the main arguments that was advanced for that was, old enough to fight, old enough to vote.
Yep.
And not knowing the science behind it, I don't know if 18 is the appropriate cognitive age for one or either of those rights, or what it would be. But as you said yourself, there's also sort of this assumption in this tradition in American law that you sort of gain rights and responsibilities in sort of balance, that they come in conjunction with one another. And so I guess my question is, how do you sort of balance, your want to create a more cognitively appropriate law with this idea that we are supposed to sort of dole out rights and responsibilities in equal measure?
So I think my approach, if anything, is more consistent with that, because it's recognizing that there's no magic sort of cognitively right time. It's just that it needs to be part of a whole process of growing up, and that we as a society play an important role in that through our laws, among other things. So, I mean, the particulars there, right? I mean, the thing to sort of note about that is that the chronology. You're absolutely right. There's a real pressure after we were, sending very young people to fight in Vietnam. That was sort of how can we, and they were being very, responding in a very political way. They were protesting, they were doing sit-ins and everything else. It's like, we're going to say that they can't be a part of the voting process, right? So there was a lot of pressure to bring those things together. And I think that was a coherent way of bringing those two things together. That being said, it had all kinds of implications going forward that were destructive, right? So 18 became the new age, and a lot of other things that had been tied to 21, recognizing that our young people are still quite dependent. For example, they're still going to college. They're often economically dependent on their parents through to 21. Suddenly, the magic age became 18. And just to give one, for instance, in the context of custody disputes, where you had divorced families, obligations to continue paying child support started stopping at 18, and the lower earning custodial parent was having to try to pay for college all of a sudden because now, adulthood is 18. Well, that doesn't make sense. But I mean, I'm completely with you on the sort of the general idea that you have to think of it all together. I want to resist the part of your question that assumes it's about making the right cognitive match. I think, forget about that. It's partly about cognition, but all these other things need to be taken into account, and we're not going to have something that's coherent across rights and responsibilities unless we think more broadly. That being said, I think you can have diminished responsibility. I think it is coherent to say diminished responsibility in the criminal context while you're giving greater rights in some of these autonomy categories. But it's because it's all part of the same developmental picture in terms of what do you gain by getting these autonomy rights earlier? Well, you gain something in terms of what you grow up to be. What do you gain by being treated as an adult while you're still growing up, and we're recognizing you're still growing up in the criminal context? Will you lose your opportunity to grow up into this person you could otherwise grow up to be? Yeah.
You touched briefly on one of the reasons for differential juvenile sentencing being giving juveniles sort of the opportunity to rehabilitate and to continue developing their decision-making system so they can be fully functional adults later on. But with the current state of our juvenile justice system, especially now in New York with investigations into their facilities, do you find that it might be having the opposite effect, that these facilities are so, in such poor condition and the children in them are not getting the individualized attention that they need, that it could actually impede their decision-making skills and make them, not sort of accomplish this goal of rehabilitation and making them better decision-making adults? And how do you see that system reforming?
Okay, so first a little qualification just sort of on how you've characterized what I've said, and then very much taking up that question. So I'm certainly not, so I really want to stress, it's not just about allowing them to become better decision makers, it's also allowing them to develop a sense of who they are in a way that is productive. And I think so. I think that as part of it is this narrow sense that it's just about decision making and how good their decision making is. But there are all kinds of problems in the juvenile justice system, what you're talking about. I mean, we have, yes, you're still here. Someone here, Randolph Stone, who knows much more than I and on that topic. So there are two questions. One is, do we have nearly as good a system as we should if we're really interested in giving everything we can to help with that turnaround and the successful development? Absolutely not. Is the juvenile justice system better than what happens if they're treated like adults? Well, you're killed, obviously that's the most extreme, but the alternative we're talking about is otherwise being treated like an adult, which means sort of, right, a sort of being an adult facility like. Worse, developmentally, predictably worse, absolutely, right. So I couldn't agree with you more that we fall incredibly short, right, and even when we are aiming toward a system that seems to be still hopeful, but the system that does not reflect hope, that says, now you're an adult, too late, where you're out of that protective bubble of childhood, is clearly developmentally much more destructive for young people. Anything you'd want to add, Randolph?
I have a question about repeat offender minors. So, and what social science says about their capability to actually develop. Because if we take your approach, and there's this class of minors that actually don't have that capacity, I'm wondering how you would treat them as sort of a subset.
Yeah. So there's some really interesting. This might be an example of good social science. Here's an example of good social science that maybe can be put to productive use, but also comes with some dangers. There's a particular researcher, Terry Moffat, who has done research of her own and looked at a lot of other research, and basically concluded, and I think a lot of people think that she's onto something, that there are two kinds of juvenile offenders. And most juvenile offenders, actually, maybe the best thing you could do is leave them alone, or at least leave them enough alone that they don't end up sort of socializing in a way that produces criminogenic behavior and takes them out of school and all the kinds of destructive things, right? If everybody's violent crime drops off, you get 20s, it's remarkable, and it's like get into the mid-30s, right down. And then there's another group that is, life course persistent. Yeah, I've got the term basically, but you get the idea that there are some individuals, they are a very small proportion of the juvenile offenders, but they end up being responsible for a huge amount of the crime, and they predictably will continue to offend throughout much of their life. And so that group you're going to be much less hopeful about, right? So one thing you can just say is, well, man, you can't tell who they are. It'd be pretty dangerous to try to pick them out if you can't tell who they are, right? And it seems bad to say you have to wait and see, but maybe that is the best result. But the other thing to say is these individuals, for the most part, have serious mental illness, or if not, usually serious mental illness or some kind of thing that you could point to as sort of a neurological deficit, or life circumstance imposed behavior that is so strong that it's just sympathetic in the form of mitigation, like they've been so badly treated. And so, I think parsing it makes you think, sort of just want to think deeper about what are we saying about development and then how we cash out what we understand about that development. We would learn that this is a different group and we should think of them differently, but does it suggest, aha, we've found the culpable ones? Or have we identified a group that maybe is at the top of the list for sort of being less culpable in light of their circumstances and their physiological makeup and the like?
I've question about using the identity formation, sort of, so you felt that Roper should have focused maybe a little bit more on that. And my concern is that that's, and I may be wrong to have looked at the science, but that may be much less solid than the cognitive development. And in fact, by saying that you think the law can shape identity formation, you sort of admit that, right? Which is that, and that's not necessarily a bad thing for you, but the point is that it's not going to be solid. And so if you're going to incorporate it, it would have to be standards, right? It
Okay.
could never be rules. We could never sort of draw.
Okay. Yeah, but I don't think either are as solid as you're assuming. I mean, there's certain things that clearly, we can't do when we're just born, and we can do when we're two, right? There is some hardwired physiological aspect to development, and I don't want to, so I'm not overfighting that. But in terms of the things that matter, in terms of what we've cashed out as matter, in terms of assigning rights and responsibilities among adolescents, there is, number one, a great deal of individual variation, which gets to this aggregation point. But more than that, it is understood to be, and there's a whole line of child development that I talk about in the paper version of this that I didn't get into, sort of culturally influenced in terms of those capacities as well, right? So you have cultures where the level of functioning and capacity of adolescence in certain contexts is way above, way below what we see with our adolescents. Well, it's not about hardwiring. That's about the culture in which people live, which can be shaped by law. So I think even the cognition, we should assume that can be affected by our expectations and how those expectations are communicated and the rest of the context in which children live. But the other thing I'd say is, I don't mind less solid, because I don't want the law looking to the social science and saying, okay, it's solid, this is therefore the legal answer. I want law taking responsibility. And so the fact that we may be able to, with a little more level of confidence, say when such and such occurs is not a reason for the law to sort of turn the decision making over to social science. But there's another thing, which I wouldn't use the word solid, so it may not be what you're getting at, but I think is really important about the difference with identity development, which is the assumption with cognitive development is that we're all going in roughly the same direction. It's just a question of how fast we get there and whether we get to some of those milestones at all in some cases. Whereas identity formation is, it's just, right? We could go in any direction. We're eventually going to become more fixed, meaning more certain and less changing about who I am and how I see my relationship to the rest of society and the like. But the endpoints could be, here or there, right? And for me, that suggests it's particularly important that we worry about it, because I think it matters more for effective adult citizens that we have people who understand themselves as, part of society, and government is of the people, and that really means me too, and I have responsibilities, and I also have rights in connection with that. I think that's actually much more important for the functioning of our democracy than being able to engage in abstract reasoning about all sorts of things. I mean, we seem to function pretty well in a system of democracy where people vote for the dumbest of reasons for, yay and nay, or, kind of don't even understand who they're voting for. I'm not proud of that. But it seems more problematic that we have individuals who grow up and really learn from their experience, including their experience with the law, that this is, that my government, my society isn't really mine in ways that have implications for my responsibilities and functioning. Yeah.
I was just going to say, I just worry if we, as people who care about juvenile justice issues and rights for kids, want to get rid of something like a juvenile life without parole sentence, the whole thing about focusing it all on how much we care about how they turn out as adults sort of disappeared, because the system, by imposing that sentence on them, is saying we don't care what happens to you ever for the rest of your life. There's no concern there about an adult citizen reintegrating and being a proper functioning citizen. It's part of the sentence that that's never going to happen for you. So I don't know how much that does.
Yeah, the question, and what's really tricky about is the extent to which we can say there's any kind of a constitutional right to have this safeguarded period. But I think that's at least part of what's going on in Roper. I think if I were, right.
Care about if there's a huge, a substantial portion of kids who we really don't care at all, then why should we care about them? Like why is the
Right, but the pushback is that shouldn't, that's, you know, and the question is whether you can justify this in constitutional terms, but the pushback would be that that's a mistake, right? I mean, it's really interesting when you look at those arguments. I mean, maybe you've read them or maybe you saw them, but how much hope comes up. I mean, I don't know, it's because it's like, you know, the 2008 election or something, but that it's remarkable how much they're trying to capture this idea that the law is sort of designed to hold out this hope for it. It seems a little corny and it seems really soft, and you kind of wish they did more with it. But that's basically the idea that they're the argument. Yeah.
In terms of using the developmental evidence, is there any reason to believe that institutionally the Supreme Court or legislature should be making particular decisions?
Yeah, so I really like this question. Of course, I think it's a real vulnerability to any of this. It's like, oh yeah, it's all good and well, but what the heck, you know, we want courts doing this? So here are a couple thoughts on that. First of all, as a general matter, I think legislatures are much more situated than courts to think about all these questions, right? Across the board. I believe that the court has a role, the Constitution plays a role, it limits that democratic decision making, but we should be pretty humble and pretty limited. When the court does step in, when we're in the terrain of saying there's some legitimate constitutional question, we're trying to figure out whether some kind of restraint is appropriate, I think a part of the inquiry should be we should be thinking about the effects. So in general, I'd say I'm with you that we should be concerned, but I think the caution goes to the whole ball of wax of constitutional analysis. Once we're in this business, I think it needs to be a part of, as I say, both sides of the balance. But the other thing that's sort of interesting to think about is, I mean, this is a little bit of the sort of gamesmanship that one only plays around Chicago, but I think that's sort of interesting, is that one of the arguments is that we have a democracy. We believe in a democracy. We have democratic decision making. If we make mistakes, we can correct them faster. And most of these things, who knows what the right answer is? Who knows? The social science points all over the place. It should be the people's decision, right? We make some exceptions when we think individuals are not part of that process of deliberation and are kept out of that process, right? For some reason or another, discrete and insular minorities, blah, blah, blah. Okay, so it's interesting to think about children. The court has only very occasionally sort of thought about how to think about children, and the most direct pronouncement, Justice Marshall said, no, they're adequately represented by all those adults, some of them who directly care about them, but all of whom used to be children. And it's just we all go through this and we eventually become these adults, so they do have representation, so we shouldn't worry that they don't have that. Well, the more you're convinced, as I am, that these adults we produce are really not what they could be, and the more we're thinking about could we do better, the less we really want to defer to those adults who used to be children for that decision making. So I think my argument adds to this to the notion that there is something about children that qualifies more in the category of unrepresented and therefore more appropriately safeguarded to some extent, again with the humility of how limited the role should be generally. For the courts to be involved. Yeah.
I'm wondering what you think about things like other kinds of ways that children are involved in courts, like the foster care system or maybe custody proceedings, where children's interests aren't opposed to, it's not like an autonomy interest opposed to punishment and isolation, it's an autonomy interest opposed to the best interest of the child. And the court is making it
They can't work it out on their own. The system would sure prefer they do, but they can't work it out on their own. They go to court. The court's going to have to figure out how to allocate custody between two people who are basically both deemed to be appropriate caring parents. They just really don't get along with each other. There are lots of qualifications to what I'm about to say, but my general idea is for the same reason that we wish it would stay out of court altogether, we may want to minimize the child involvement in that process. It's highly, it's antagonistic, adversarial. The child loves both parents and just wants it to be over. I don't feel that children who want to have a chance to speak shouldn't be, I said that double negative unnecessarily. Children who say, I really want to be in there, I want to be, I think they should be respected for that wish. But I think ultimately we're really unhappy that there needs to be a court rule at all, and we're really interested in minimizing it in terms of what we're trying to accomplish in that context. In the foster care context, by definition, we have a child who has been separated from that family, who is in some way, has a corporate parent. Even if they're living in foster care, they are the custodian of the state in a kind of way that, first of all, that's an important legal distinction. Number two, they are already in the midst of a terrible antagonistic situation where the issue is much more likely to be, why don't I have any control over this situation? Does anybody want to hear, like, I actually know something, right? And I have, as you may know, I've focused particular attention with the help of some law students who've now all graduated, I guess, working on a foster care project that focused on the oldest foster youth, where we ended up taking a very strong position based in part on our understanding of what's going on developmentally, that those children need to be in court. They need to be in court a lot. They need to not just be there. They need to be engaged in a way that might even require a diminution of their lawyer's role to ensure that they are really, one, gaining the, it's not just sort of right to be heard, it's also gaining the experience, being someone who is engaged in the decision making and the sort of the related bundle of issues. So I would say it depends on the context. You think about the context, you think, what is it that we hope children will learn from this? And that's why I think, again, in some of these process contexts, you have the most relevant implications in terms of how it's really going to have a real effect. We're done? All right, thank you.